as to cognizable and non-cognizable offences, and then we talk about the procedure of investigation. So the police has a part to investigate cognizable offence, and what is that part is something very importantly highlighted here, because that part is exercised without any express order from the magistrate. So that is why it's been specifically mentioned in this legislation, because even the power to investigate is controlled by the judiciary in this country under this criminal justice system, and therefore this provision is very pertinent. You must note down this provision, section 156. Then section 157 talks about the procedure for investigation, how investigation would go on and what are the nitty-gritties of that. Then there is the police officer's power to require attendance of witness. Now this is very important. A police doing an investigation will always require witnesses to give them a true picture of the case. However, again, the witnesses should not be unduly burdened. They should not be unduly harassed as such, and therefore this provision becomes very important in respect of that. Although all of this might seem something that you already know, but it's very important for us to understand how it fits into the scheme of things in under the legislation. It's important for you to know that whatever you have been thinking about the criminal justice system is explicitly there in the criminal procedure system, which is criminal procedure code that regulates this system in this country. So this is section 160, and section 161 talks about examination of witnesses by the police. And 162 is very important because it talks about the evidentiary value of the statements that are made to police, because it's not a substantive piece of evidence. It can only be used to corroborate the case of the witnesses while in a court of law. So it's not a substantive piece of evidence. Then comes section 164. This has a very straight connection with the Indian Evidence Act. It's about the recording of confessions and statements. Under the Indian Evidence Act, it's written that whatever you speak in the custody of a police officer, please tell me if I am wrong. Whenever someone talks about something in the custody of a police officer, that is not to qualify as evidence. Actually, that's not because it's admissible evidence. Yes, the word is admissible evidence in a court of law. So what is to be? How will you ensure that confessions are made? Because confession. Yeah. See. Yeah. So if that could be ensured before a judicial magistrate, with all the due guidelines followed, that okay, the magistrate will tell you that okay, whatever you are speaking may go against you. Whatever you are speaking, it has legal consequences. So all of these things are provided for under section 164 of Criminal Procedure Code. It tells you how confessions and statements, because the statements are witnesses and confessions are accused, to be made in the legislation. After that, there is a provision as to release of accused when evidence insufficient. So you might want to read this, because if someone comes to you tomorrow in your legal aid clinic and says that my relative is being detained and the evidence is not sufficient, you might just want to refer to this provision as to how it might prove useful for you. It is section 169. Now if the evidence is sufficient, what is to be done? Then the case is to be sent to magistrate, and that is section 170. Now comes another important thing. You always know the importance of a diary. Okay, so there is a police diary as well, where you need to, but again, there now comes a problem. There is a case diary as well, and I don't know the difference. Okay, so I'll have to find the answer to this question as well. And what a police diary is about the proceedings of investigation. Okay, so thanks for that information. Now I'm clear about it. So what he said was that a case diary is concerned with the first information kind of a thing that comes to a person. Okay, so it's a general diary, yes. So it's about like every offence that is being committed, the first information of that report is usually mentioned in that diary. So that is a general diary.
And a copy of that is given.
Yeah.
And another copy of that is given to the person.
Yeah. And the case diary is about a specific case which pertains to the record of investigation of that whole case. So that the records of an investigation are to be put in that diary. And I think this provision talks about the case diary and not the general diary. This is section 172 in chapter 12. So this was all about the information and the investigation under CrPC. Now we come to chapter 13, which talks about jurisdiction of the criminal courts and inquiries and trials. Jurisdiction is a very important point. When you go to moot courts, the first point that a court will ask, do we have the jurisdiction in this case or not? I think that's the most confounding question in this university is faced by every mooter. Like when I was a junior, like first year, I used to like run to my seniors and ask, so jurisdiction kya hoga? Jurisdiction kya hoga? Or when I became a senior, then people used to like approach me, although very seldom. Like I would say, people don't usually approach me for all this and that. They don't consider me so informative a resource. So like, but if they come anytime, they would ask the jurisdiction kya hoga. So I usually am not able to answer their queries, and that's why they don't approach me. So there it is, chapter 13. It talks about the ordinary place of inquiry and trial, and place of inquiry and trial not in ordinary cases. So this is section 177 and section 178 of this legislation. Now comes the conditions requisite for initiation of proceedings. Here comes the importance of judicial notice of the case, and that is what when people refer to here as cognizance. So who takes the cognizance of a case? A magistrate. So magistrate takes the cognizance of a case under section 190 upon receiving a police report or upon receiving information from someone else, or when he receives information from a magistrate himself, or if he himself has that information. So based on that, under section 190 he takes judicial notice of the criminal proceeding that has happened, and that would be a judicial notice of it, and that marks the initiation of a criminal proceeding under CrPC. A criminal proceeding, mind you, it's not the initiation of the trial. Trial is separate thing altogether. It's the initiation of criminal proceeding through cognizance of the case. A sessions court can usually not take cognizance of the case. It can only, a magistrate could only commit a case to the court of session, and only then the court of session can take cognizance of the case. So that's provided under section 193. Cognizance of offences by courts of session. Not by itself, only through magistrates. Only when it's committed to magistrate. The magistrate commits the case to court of session. Now after that, chapter 15 talks about complaints to magistrates. Complaint is already defined under section 2B or 2C of this legislation. I think it's 2C. Yeah, 2D it is. 2D complaint. So it talks about any allegation made orally or in writing to a magistrate, and therefore there is a separate chapter about complaints to magistrates, and I won't talk about it further. I'll move on to commencement of proceedings before magistrates. So now here comes the issue of process. A process is again the summons and etc. because the issue of process marks the beginning of the commencement of proceedings before the magistrate, and here this is the stage where the magistrate may commit the case to court of session when it realizes that the case is exclusively triable by a court of session. So this is in chapter 16.
This is the point where trial starts.
No, the trial starts only when the framing of charge, and that's the next stage. Yeah.
In how many ways can you file an FIR?
See, like she wasn't here when I was providing the ground rules of this class, but she's of my batch. So, like, I told you not to ask questions.
So 3 ways did you cover that? That is what I wanted to ask.
I have a right to silent knowledge.
Can you cover that portion in 3 ways you can file an FIR?
I'll cover it later. That was further embarrassing. So different forms of FIR. That's the third topic that I've studied about. Anybody knows about it in this class? I know that's too bad to ask, but like still, okay, I'll definitely tell you about it. So after that comes chapter 17, the framing of charges. So the framing of charges marks the formal commencement of a trial process. And the charge sheet is very important because it gives the almost every description that is pertinent to the initiation of the trial, because a charge sheet should not be deficient. If you want to have an access to a practical charge sheet, do you want to have an access to it?
Yes.
You need not go to a police station. Go to Indian Express of yesterday's, and there is a page which comes in explained.
Yes.
Yeah. That's not simple. And under that there is a section simply put, but just at the very bottommost section there is, it talks about NIA's charge sheet concerning an incident that happened in Darbhanga where a Congress legislator was killed. So in respect of that, an extract has been provided there out of the charge sheet of the NIA. So although that is a comment on the charge sheet, but that need not concern us here. What I'm trying to make a point here is that when you read it, you come to know what is the content of a charge sheet. So today is 24th. The paper is of 23rd, and it's in section explained. You can also access Indian Express free of cost online, so you might just find it there. So make a point to read it. That's very interesting. And I just came across it yesterday, and I was very happy. Yes, I have something to talk about in this class. So it's a good thing. Then. So this chapter talks about the contents of a charge and particulars as to time, place, and person. Like the basic idea behind this chapter is to ensure that the charges are so sufficiently defined that the person who is actually being charged knows as to what is being charged, because during the trial that will frame the basis of his defense. He should not be unreasonably charged with something which he has not done. So that, because the charge sheet is very important from the point of view of a trial. And secondly, it is framed in such a way to direct the court as to what direction the trial process will take after the filing of charge sheet. After that starts the trial. Chapter 17, which talks about trial before a court of session. Then there is chapter 19, chapter 18. Chapter 18 is trial before a court of session. Then there is a trial of warrant cases by magistrates. And then there is trial of summons cases by magistrates. And then there is summary trials. So there is trial by sessions court. There is trial in respect of warrant cases before a magistrate. Trials in respect of summons cases before magistrates, and summary trials. Summary trial procedure to a significant extent is same as trials in case of summons cases, because summons cases are naturally less serious cases. So this the provision here itself says that the procedure for summary trial, section 262, is to the extent of the provisions mentioned in this chapter, same as the procedure followed in summons trial. So you might just want to go Yeah. Yes, I know you are permitted to ask. The only difference between these two kind of trials is in relation to the evidence. The 2 years thing is there in the definition, but the primary difference is in respect of collection of evidence, which happens in a summary in the summon cases, because in a warrant case, the court has to maintain specific records of every evidence that is taken, because when it goes to appeal or revision, because the records are called for examination by the appellate court or the revisional court, then there every evidence is scrutinized very particularly. But in summons cases, it's sufficient to maintain a note of what evidence has been received by the court. So that is a primary difference as far as I know in respect of the difference between both these two. Like it's in relation to the evidence. In warrant cases that are serious cases, it's meticulous collection of evidence and meticulous preservation of it. However, in respect of summons, it's merely taking notes of evidence, just as to know what kind of evidence was there. So it's not so serious collection of evidence, not so serious preservation of it as well. And then we have summary trials, chapter 21. Then we have chapter 21A, plea bargaining. Now with plea bargaining comes a corresponding concept of compounding offense that Manik sir was discussing about yesterday. I had a curious notion as to what is the difference between compounding of offences and this plea bargaining? So I think I can just give you a basic difference. Compounding of offences leads to acquittal. So this means that it's like your trial has started, and the trial is not started. In compounding, what happens is that the right of trial that the victim has is waived off in respect of this, and so you are acquitted. However, in respect of plea bargaining, what happens is that you are let off on a lighter sentence without a trial. So it's kind of this, that there is no trial happening, but you are let off without a trial. And in compounding offences, what happens is that you are acquitted totally. So those are the cases where you could compromise with a higher.
So is it like compounding is between parties, where plea bargaining is between party and the prosecution?
I'm not so aware of this exact procedure, but I think plea bargaining definitely has the intervention of the court, because see, in plea bargaining we are not doing away with the trial process altogether. In compounding, it's a compromise kind of a thing right between the parties. But in plea bargaining, your sentence is reduced. It's not completely done away with. We are accepting your guilt. So, but you might want to just read about this more, so that you be sure about it. I'm not so sure about it. And that is the basic thing. Then after plea bargaining comes the attendance of persons confined or detained in prisons. So if there is a person who is confined in prison who might be required in a court of law, then what is the procedure to ensure their presence is provided in chapter 22. And then there is chapter 23. You might have got a hint that from here starts the thing about witnesses. So chapter 23 is about evidence in inquiries and trials. So here is how evidence is collected in a trial, and how commissions may be issued. Commissions are like, the witness doesn't come to the court, but the court issues a commission to take evidence from that witness. It happens in cases where the court feels that it's not practical to call the witnesses because it might lead to delay. And more specifically, it happens in the case when evidence is to be taken off from a president of India or some other important constitutional function, like the governor or someone, a constitutional function in mind. So that is there. Those functions are specifically provided for under this legislation. Then there comes provisions as to accused persons of unsound mind, chapter 25. That is something very different altogether from this process. And provisions as to offences affecting the administration of justice. So if you are actually obstructing the administration of justice itself under this procedural law, then there is chapter 26 to take care of that, how the procedure would be there to deal with such offences. Again, the offences are mentioned in IPC, I believe, and what is the procedure for enforcement of such provisions is in chapter 26 of CrPC. Then chapter 27 is about the judgment. The judgment has to be in which language it is to be, and there it is. This chapter is important in the sense that provides for payment of compensation for the victim. So this is very pertinent from a point of view of legal aid. So you might just want to note it down. It's section 357A, Victim Compensation Scheme, and 357B and C also. 357C talks about treatment of victims. I think these have been introduced by the 2013 amendment after the Delhi gang rape case, and it is like about treatment of victims as to how that compensation should be channelized to protect the victims of rape. But you might want to just check it once. Okay. Chapter 28 is about submission of death sentences or confirmation, because the court of session can give a death sentence but subject to confirmation by the High Court. So this is the procedure for it here. Chapter 29 is about the appeals. 30 is about reference and revision. 31 is about transfer of criminal cases. Execution of sentences like death penalty and all this, how they are to be executed. Like in CPC, execution of the awards of the court, award of the judgment of the court decree. Similarly, we have execution of sentences, and that is in chapter 32. Then we have the most important provision, which I won't need to discuss in today's class, and I really didn't want to discuss it as well. It's bail and bonds. Everybody knows about it. There are like bails in bailable offences, non-bailable offences, and anticipatory. Anticipatory bail is not relevant in respect of UP, but there has been a petition in the Supreme Court as to like restore that position in UP. But bailable and non-bailable, bailable offence is one where you have the bail matter of right, and non-bailable is the exact opposite. You might get a bail, but not as a matter of right.
It's discretion.
But in India, bail is a rule.
And jail is an
Bail is an exception.
Like if you just say that admissibility gain is not exactly a crime and accept it, because there's a fantasy that you got about it.
Even anticipatory bail doesn't, it says in the provision itself that once you are arrested, you will be immediately released on bail. It doesn't say that you won't be arrested at all. It only says the moment you are arrested, you will be released on bail.
Is also about application of but the question of bail only comes into being when there is actually a offense. So on this ground, try to make
Yeah, so that's a very important point that you have pointed out, and that is in respect to bail and bonds. Then we have 35 irregular proceedings. So there might be departure from the rules which are there in the CrPC. So which departure would lead to will vitiate the trial process and which will not is provided for under chapter 35 of the CrPC. Then we have limitation. So there is indeed a limitation for taking cognizance of offences under Indian Penal Code. So that is provided under section 468. That is a very important provision, though I know about it, but I won't discuss it here. I really know about it. That's a genuine statement. Because I have been telling expressing what I don't know. So yeah, but section 468 is very important, so you might just want to read it. And then there is miscellaneous, and then there are forms and forms and forms. Thank you for the class. Thank you for